after the decision or court judgment declared as valid and binding after periods of time. For instance, in civil proceeding in Indonesia, there is 14 days for the lost party to submit for appeal. If it is passed, elapsed for 14 days, then the decision or the court judgment can be declared as Berkekuatan Hukum Tetap, or binding, final and binding. There is another way to challenge that. We're going to discuss that once we got into the topic of legal remedies. Having said that the decision is now final and binding, so there is the rights of the winner to get the opportunity to execute the court judgment. So the question is how it's done. Okay, so in Indonesia, in civil proceeding, there are two types of court judgment enforcement or pelaksanaan putusan pengadilan di perkara perdata. The first is if the lost party voluntarily perform such decision, meaning that after past the 14 days and then it is clear that the defendant or the lost party specifically should perform on something and he or she doing so, and then it's done and the case is settled then. However, in many cases, the lost party did not comply to perform voluntarily. In that case, then the court can help the winner of the case to execute such judgment. This is what we call as execution, or in bahasa eksekusi, atau pelaksanaan putusan secara paksa. Meanwhile, if it is voluntarily performed, it is called as pelaksanaan putusan sukarela. So you can check on the discussion on whether the voluntary enforcement need the presence of the court or not, and then whether court should be active or passive. You can check on my PowerPoint. Next, we're going to discuss about the execution itself. If the lost party did not comply, so the court can enforce. So there are three we're going to discuss the types of execution. Specifically, there are three types of execution. So bear in mind, we're going to discuss about execution once the case is settled. It's different when we talk about sita or seizure during the course of trial. So before midterm, I believe you already discussed with Bu Haryana. There are two types of sita or seizure in Indonesia. Sita jaminan, or during the course of trial, and there are three types of them: konservatoir beslah, marital beslah, and also revindicatoir beslah. This one that we discussed just now, it's different because the case is already settled. So the aim of execution is to give back to restore the situation of the aggravated party. So according to HIR and also Sudikno Mertokusumo, you can check on my PowerPoint page 30. There are three types of execution, and also there is one, this is what we call as development outside HIR and RV. So first is monetary punishment, second is performance punishment, and real execution. Whereas the development of execution, want to mention, it is not mentioned in HRR or RV, but from what it is mentioned in our civil code. Okay? So first we're going to discuss about the monetary punishment. So if it is the monetary punishment, then the lost party can just pay or wire the money as it is ruled by the court decision. Whereas there is also what we call as performance punishment. So what types of performance can we ask someone to do something? Wouldn't be like labor, for instance, because this is civil case. For instance, in civil cases, in tort case, for instance, or perbuatan melawan hukum, within the ruling, judge can also order, for instance, the lost party should hold a press conference as a public apology, for instance, or to order such injunction not to continue to do something. That is what we call as performance execution. So in the case of going back to monetary execution, you can check on my PowerPoint. So not only money, necessarily money, but it can be also stock or obligation or any movable good that can be valued as money. So what about if the person, the lost party, do not have money but got a house, for instance? So the court can help to seize the house and then did the auction. In a case of a failure to pay credit or loan bank, so there is a way of the court to do lelang or auction, and then it will be counted how much did the lost party owe to the winner or the creditor. Okay, and you can check on there is some exception to monetary execution, so we cannot seize type of a very substantial earning life of some family or some or people, such as tools or cattle for earning life, and we cannot also seize certain rights to the law, such as compensation, damage for labor. We cannot seize that. So although yes, it is correct, we want to uphold the rights of the winner because already been damaged by the lost party. However, we also have to make sure that we're not violating the human rights of the lost party. Okay, so not to a very essential tools or rights that the lost party has. Okay, so that is monetary execution. Next is real execution, because I already mentioned previously about performance execution. So this is what we call as eksekusi real. So eksekusi real, if you check on Sudikno Mertokusumo book, this is in general meaning that some lost party should leave a property that has been in disputed by two parties. Okay? For instance, the lost party should leave the house in dispute because he already lost the case. Okay? So that is for real execution, and there might be a joint types of execution, not only monetary execution but also real execution. Not only as for money payment of money, but also ask the lost party to leave the house, for instance. So there is also some exception when it comes to delay of execution. How could we delay if there is amicable settlement? Since the beginning already mentioned, it's all about parties. This is civil case. If parties settle, then that's fine. And there is also problem for encounter such as humanity reason, while they want to do real execution, the lost party doesn't have yet a house to live for temporarily, so they can ask for a delay. Okay? And there is a possibility of a final review, or what we call as peninjauan kembali to Supreme Court. It is also reason to delay such execution. And that is all for court judgment enforcement and execution.